To cover. I want to very briefly tell you about VLS. I welcome you to VLS, and your interest in VLS is very much appreciated. There's a great deal of good that lawyers can do for the charitable sector. Terry and Bill have told you how charities and nonprofits have the same business legal needs as any other business, any other organization. They need to incorporate, they need bylaws, they need to learn how to govern themselves, they have employment issues, they have leasehold issues. It's all very similar. By offering your pro bono services, you can provide an invaluable service to these organizations and thus their clientele, who are often the poor, the disadvantaged, the marginal, the arts groups. We provide services to a broad range of charities and nonprofits, but the bottom line is that they have to have a benefit to the community. You can give them advice on a one-on-one basis on a variety of legal issues. You can deliver seminars for VLS on how to incorporate, how to obtain charitable status. We run a series of seminars that are very successful. You can give us articles that we can put on the website that reach an even wider audience. I've said that the needs of these voluntary organizations are very similar to any other businesses, but what they don't often have are the resources. They don't have the fees to pay for lawyers, for accountants, for all the various business needs that they have. And with us today is Ann Pyke of the United Way of Greater Toronto, back here, to speak to you about the need of these organizations. Ms. Pyke is a senior manager with the United Way. She has worked with agency services for many years. She's well aware of the needs and capabilities of the voluntary sector and how that has changed over the years as governments have increasingly withdrawn their funding while increasing their expectations. Ms. Pyke works to build the organizational capacity of United Way member agencies so that services can be delivered effectively and efficiently. The United Way has worked in partnership with VLS for many, many years, and Ann has one of the critical factors of why that relationship has been so successful in the past. Ann?
Thanks, Shanthy. I am here to echo what Shanthy said and more. As she said, my function at United Way is often what I call to provide the icing on the cake. And the icing is often a lot more fun than mixing the cake, which can be hard work. What United Way does is to raise money for nonprofit organizations that are part of its membership to pay their rent, pay their executive directors, run social programs, do outreach in the community, work with seniors, adults with disabilities, youth in Jane Finch, Regent Park, a plethora of different social causes. What I do is a very small part of United Way and somewhat unique among fundraisers in Canada. It is something that is far more prolific in the United States, and we are starting to see, I think, the crest of a wave coming from the States. And the essential concept is, the idea is called organizational capacity building. The essential concept is that it's an excellent thing to provide funding for organizations. And it's a really wonderful thing to donate to United Way or any other organization of your choice, to give of your financial resources. But when volunteers, United Way staff, can actually go out and educate in the community in order to increase the capacity of the individuals and organizations that these places serve, you're actually creating a higher sense of stewardship. That is our sense anyway. Money, donations are a fabulous thing. Helping people use that money in very effective, efficient ways goes even beyond an actual donation. So in United Way's whole function, we work with all of the groups that Shanthy enumerated. I would detail those a little more specifically and tell you that one of the main groups that I've noticed most are newcomers to Canada. And many of these individuals have PhDs, They are lawyers, they are doctors, they have master's degree, they have HR certification, many, many professional designations. However, unlike yourself or me, they're in a new country, in a new land, in an unfamiliar territory. And they are in need of housing, they're in need of food, they're in need of English, they need to break through social isolation. But I think the most difficult thing for them is the inability to practice what they trained for and what they learned about and what they spent their lives doing in their home country. So this is a group that United Way particularly wants to reach out to. And whenever we come across those individuals on boards of our organizations, in the programs, we attempt to link them up with some of the professional volunteers that we work with in organizational capacity building, which is my area. So then I think you're seeing what you could see almost as a tripling of good, in that you're able to provide a volunteer with Canadian work experience, a lawyer, an accountant, to actually work with the agency. You're able to network a new Canadian with that professional, and you're able to leverage the volunteer capacity of both those individuals within the organization itself. So that's the essential part of what I do. The areas that I work in cover law, accounting, human resources, access and equity, and particularly within law, board governance. It's a huge, huge area for all our nonprofit organizations. I wanted to give you some sense of the volume of requests and need that is out there simply by going over some of the statistics and some of our work with VLS over the past 2 years, because this may be considered, although perhaps not for lawyers, a fairly esoteric area, but we are convinced that organizational capacity building, particularly through nonprofit boards, is a key way to leverage community resources and help organizations have the greatest impact upon the neighborhoods that they serve. For example, in 2003, we worked with the Volunteer Lawyer Service to offer workshops on liability and accountability. We were only able to get a room for 60 people. We had to call City Hall and get a room for 100 because the overflow was so huge. We had a waiting list, so we offered it again. I said, we hit the ceiling on that one. We'll have about 20 people, but it'll be a nice, more intimate seminar. We can do it, more question and answer, deal with people's issues more directly. Again, exactly the same numbers. We've run 3 times in 1 year workshops and seminars with an HR professional and a lawyer on wrongful dismissal, because as Shanthy said, our organizations face exactly the same issues that organizations you might represent or work with as lawyers do, yet they don't have any basic infrastructure. They don't have an HR department. They don't have counsel. They don't have an IT department. All these things they lack, yet they have all the same human problems of organizations and the external environment of a community of need that surrounds them. We've done the Employment Standards Act, I thought almost to death, but no, the calls started coming in. When is the workshop in 2004 on the Employment Standards Act going to happen? I myself have had to become far more familiar than I ever imagined with the Ontario Corporations Act, because we have call after call after call. Individuals want to know, how long should I stagger the terms of my directors? Can I actually have directors with terms that are varying, 3 to 5 years? Well, I actually discovered you can't, because I grabbed my Bourgeois, which I was forced to buy. It's an interesting publication for a non-lawyer. These questions people do not know the answer to, and they can have serious organizational implications if they don't have access to a lawyer, if they don't have a lawyer on the board, if they don't have an information and referral service that you could call up and ask a lawyer. They end up asking me or the United Way, which just scrabbles to do the best we can. AGMs, absolutely. We've developed and run seminars on that, hugely attended. The somewhat stupefying area of bylaws was wildly popular because people sometimes don't understand that you just can't do anything you want with your bylaws. There is a very stringent code of what has to be done around that. So they call us, especially after we offer these workshops, and they're very interested because by and large, they want to do the best for their communities, but they just don't know the answers. And this is what I hope that this series of CLEs done with the VLS will be able to assist to increase the numbers of lawyers who are able to offer this kind of assistance to nonprofits. And this will be of huge benefit to our organizations and to organizations throughout the city. So I'll stop here and just see if there are any questions. And if not, Shanthy has my name and number at United Way, and I'm happy to talk to people about any kind of volunteer opportunity you might be interested in. Any questions? Great. Yes, no problem. It always takes 30 seconds there. You've got to give that pause.
Do you know if United Ways in other cities offer series of information?
They do. Right, and I would imagine that it would be happening in Ottawa because there is a network called the United Ways of Ontario, and certainly I could get the number to Shanthy if you were interested and want to follow up with her, but many of the United Ways in the smaller areas are fairly low capacity themselves, but absolutely Ottawa, London, they would be doing this type of work. And if they're just beginning it, it's something that you, if you live there, could actually start. Because to do a 3-hour workshop on liability and accountability, you just need a smart lawyer that knows what they're talking about. You prepare half an hour of material, and the rest you've got 2.5 hours of questions. I guarantee it. Any follow-up with that? Okay. Anything else? Yes.
I just wanted to ask whether you have a need for lawyers who are experienced doing mediation or mediating conflicts within a nonprofit setting, whether there's volunteer opportunities that way or whether that's
Conflicts in a nonprofit setting. I can't imagine that would happen. No, absolutely. When you have people within organizations and outside of organizations who are under extreme stress, dealing with poverty, the pressures are immense. Unfortunately, because of changes in funding, we've had a couple of agencies we've funded implode over the last several years, simply because of that. So absolutely, we do. We run a volunteer consulting arm, so we will often take somebody who has legal or accounting background but doesn't want to work as a lawyer per se. They want to use a particular skill around facilitation, mediation, conflict resolution. So definitely, if you'd like to get hold of me, just call Shanthy. Anything else? Great. Thanks so much for your time.
Thank you very much, and we really appreciate you coming down from the United Way to let us know the situation for charities. Once again, we're back to Bill. He's going to talk about duties and liabilities of boards of directors, and I know this is a topic that's very important to charities as well.
They give you 2 mics here, and I never did figure out the first time which one was on, but it's obviously that one, so I'll leave this off. There's lots written about directors' duties. There's books. There's gobs and gobs of cases. Compared with earlier, I said there's very little written about members' responsibilities and members' rights and obligations. On directors' duties, there's books and articles and all kinds of things. So that made it a little more challenge. So what I'm going to try and do is to give you a little overview and then give you some practical sort of thoughts as to how to advise the people you're dealing with. Trying not to frighten everybody, because if you read the Riot Act to everybody would just walk away and say they don't want to be involved. but anybody who would come to this type of seminar probably has the intestinal fortitude to try and get through it and do it properly. Charity duty is higher than corporate directors. Okay, so if you have a nonprofit organization, charity director has a higher duty, and there's lots of cases and discussions about that, and the public guardian trustee will inform you that in fact they have a trustee's duty, and I don't do estates law, but anybody, probably some of you do. You probably have a better idea of that than I do. One of the things that's happened in the last year or so has been the changes in the attitude towards directors generally, and all of us that own shares in Nortel still didn't own shares in Enron, but you've heard that name in the United States, and then lots of new legislation has come through, and there's all kinds of endeavors made to try and increase corporate governance, and the way they really focus on that is to suggest directors should do things. And I guess, although I don't do securities law anymore, I still do read the report on business. And Mr. Conrad Black was in there today talking about some of his boards, and he might still reads that. That sort of stuff. And there's directors kind of wishing they hadn't been directors and done it differently. So if you get involved in advising an organization that's non-functional, then you have to decide whether or not you want to frighten all the directors into resigning. Again, that's a practical approach to things, but your your duty as a lawyer, whether it's pro bono or not, is to, in fact, to point these things out to them. Some of the high-profile boards that you'll find where there's, everybody, you get guys that wear shirts and ties to work and women that wear shirts and ties to work are on those boards, and drive fancy cars and all those things. They're all sitting on other boards, and they are involved with the Enron things, and they're making it very difficult for lawyers who act for those organizations. If you get involved in the community level organizations, which Anne's speaking of, almost all of them have 2 or 3 people that sort of have an accounting background or some sort of a business, and they'll be aware of those things too, and they start raising the questions which are in fact raising the bar. So that's a big trend in the last couple of years, and you just have to be aware of it, and tell them that this is not the Royal Bank Board that we're trying to create here. We're trying to do a little housing project here, and try and keep it relatively simple. Again, you should look at the letters patent and the bylaws, and ask the executive director or the board chair, does everybody have a copy of those things? And everybody should have a copy. Whether they read them or not really isn't up to you, but you should make sure they have that. Directors of nonprofit or charities are not responsible for the day-to-day management. Although in some smaller, I'm involved with one charity I'm on the board of, and there's no staff, so guess what? We all sort of do a little bit. But usually you're not responsible for that. And you have to draw that line, and you're giving advice to directors. And I used to be the chair of the board of one of the hospitals, and I used to use this to the people that say, if you're walking down the halls of the hospitals and you see a piece of wrapper or some garbage on the floor, pick it up and throw it out. Don't speak to the next guy who's leaning on the broom who works for the union and tell him to go and do it. That's the executive director, the president's job. But if you're going by 3 days in a row and you see it, speak to the president of the hospital and say they should be doing something. So in other words, we're responsible for the whole organization. We can clean it up, but we're not responsible for managing all those people down the road. That's a big problem you get involved in, and a very serious problem for a lot of the social agencies. When you get people sometimes on the board who have a lot of expertise, get out there and they try and sort of dig in and work with the staff, but you have to support the executive director. Your duty as a director is to help manage the organization, not actually get down there and do all the work, depending on the organization. A very important thing to remember is that for non-share capital corporations, the directors have a subjective standard. And I've always got objective and subjective mixed up for many, many years. But subjective means that you have to look at the individual person, the knowledge and experience of the individual person. So if you have a board, a charity board, and there's someone on there who is an accountant, they have a higher duty with respect to the financial statements than someone on there who is a teacher or drives a truck or a simple lawyer or something like that. So remember that. And when you raise that and you mention that to your clients, and if you get a chance to speak to the board, it actually brings the people who have expertise, they sort of straighten up a little bit. And, and they say that we're, we're going to build a new addition on the building and there's somebody who's an architect or a carpenter or something like that, they have a higher duties, and that makes some sense. That's not true for a for-profit board, so that is some difference. And I was just thinking, when Ann was talking about all the new people coming to Canada, whether or not that would make any difference if they were on the board. I mean, that's a subjective test. And so if they were on the board, one, English might not be their first language, which would be an interesting, I don't think there's any cases on that, but it's a new angle I just never thought of before. Or secondly, they come from a culture or background where what the duties that people have are quite different. So that might be a good excuse. There's three things that you should point out to everybody that should be discussed, and there's some legal implications to it. The first one, and we talked about it, directors' officers' liability insurance. You can get that. As Terry mentioned, in 2001, the law got changed as a result of efforts by lawyers and others to say that you could do that. The public guardian now says you can. But a regulation under the Charities Accounting Act says that the board of directors of a charity shall consider the following factors before giving an indemnity or purchasing insurance. So, if they haven't considered these factors, and if you're taking notes, it's Ontario Regulation 4-01 under the Charities Accounting Act, and if they have not considered these things, then technically that insurance might not be valid and appropriate. So what I do at every annual meeting, I read out these sort of things, and they all sort of sit and weave and bob, and they say we've considered, and they go and get the directors and officers liability insurance, and that sort of says it. So, and they're kind of sensible things. The degree of risk to which an executor trustee may be exposed. So if you're dealing with a children's mental health center, there's a big risk there. That's fine. But if you're dealing with a library or an online something or other that doesn't give advice on anything risky, then there may not be any. Whether the risk can be eliminated or significantly reduced by means other than the indemnity or insurance. So there's other ways to deal with it. You're supposed to have thought of those. Whether the amount of cost of the insurance is reasonable in relation to the risk. So that's just a plain business decision. Is it worth the idea? Whether the cost is reasonable in relation to the revenue. In Terry's example earlier of $10,000 gross revenue and a $3 million directors and officers liability premium, that might be reasonable. And finally, whether it advances the administration and management of the property to give the indemnity or purchase the insurance. So if you don't get those things considered by the directors, then there's certainly a position which those people who act for the insurers might take that the policy might not be any good. So don't forget to do that. It's very important. The second one is with respect to investments. All charities have some money. They should have an investment policy. And in the investment policy, and I know because I've done about 70 of these, under the investment policy, they should consider and they're required to, under the prudent investor rules, to consider the criteria under section 27(5) of the Trustee Act, and that was an amendment from a couple of years ago. And they're all commonsensical sort of things, but the theory there is if you have a charity that's trying to save money to build a building in 10 years, it shouldn't leave the money in the checking account, right? Everybody know that. If in fact you have a charity that as soon as the money comes in from the United Way or the government, they write the check to pay the staff, well then they might as well leave it there. So it really varies. And if you have a charity that is a private foundation, the private foundation has money set aside, or it's a hospital foundation, money set aside for 20 years, or it's an endowment forever, then in fact you should have different types of investments. So it used to be, and that's not the real topic here, but that's one thing you should do. And the final thing that you should be doing this year is having a privacy policy. Okay, the privacy legislation came in force on January 1, 2004, effectively applies to everybody that does commercial activities. You can argue that some of the things charities do aren't commercial activities, but probably some of them are, and it certainly doesn't hurt to have a charities or have a privacy policy. And again, my approach to all things, especially for the small charities, is when they come up with these very tricky legal questions, is try and find an answer which doesn't require, try and find a solution which doesn't require you answering that problem. Okay, that's my best advice to all of you when you're acting for pro bono charities. Okay, when they come up with these very complicated issues, don't look at it from a lawyer's point of view and say, look at all those issues, terrific law school question, or wouldn't the Supreme Court have fun with this? Try and think of what they're getting at and how you can give them a solution which takes away the legal issue. Well, they all come up and they want to do governance issues. Like I told you the example already with the members, right? So a good percentage of the people, these people are very determined, you can tell them, look, we can avoid having 14 layers of members, right? Call them benefactors. Call them friends of the charity. That's a really good, easy example. Now, the reason I went into it, because I wasn't very persuasive in this case, or not nearly as persuasive of the people that wanted to raise the money. But, they want to have all kinds, can we have our annual meeting and all that sort of stuff, Let's just have it easy. Do you have to have a privacy officer? Can you come and give us a 14-page memorandum on what the privacy legislation says? No. Appoint a privacy officer, have a one-page privacy statement, and then when the government calls, say, yes, here it is. So I mean, there's all, like the investment policy, I get vested all the time. Speak to your lawyer, give you a simple investment policy. Don't call up 14 banks and 14 brokers and get them all to do, and you got $1,000 in the bank. So I mean, that really happens a lot in governance, that sort of stuff. Do I have to have, I get this a lot, what should my minutes say? I think we put an article in there about minutes. What should my minutes say? Well, I don't think it really matters. It's whatever you're comfortable with. But when in doubt, don't say it. Don't say something that has to, I mean, you've got to, they got some real type A's. They want to make sure they write down who made every motion, right? There's nothing in the law that said you ever had to write down who made a motion. You go to a lot of these smaller charities, the first half hour is somebody saying, I didn't make that motion from the meeting that happened 6 weeks ago that nothing flowed from, right? So, I mean, everybody has their culture, and that may be the way that the chair gets everybody involved, but it should be purposeful. So there's all kinds of little things we can do with respect to that. Now, I'm just going to rhyme off some sort of ideas here. Remember, directors, big duty, the big thing you frighten them with, frankly, and they should be frightened with, is for charities that don't have much money but have salaries and maybe have some GST. If they don't pay the salaries, or they don't pay the withholding tax to the government, or they don't pay their GST, but mainly the withholding tax to the government, you as a director can be personally responsible. That is the big one. Over 50% of the cases that involve directors getting into trouble, it's because the organization basically ran out of money. They paid the people, instead of sending the money by the 15th of the next month to Canada Revenue Agency, you can sort of live without that. You have to pay your staff or they're going to leave. And you might have to pay the rent. Unfortunately, you don't have to pay the lawyer or the accountant or the professional, and you don't have to pay the government. So, and they keep saying somebody's going to come up with the money. The fundraising effort is going to be terrific. We're going to have this fundraising effort, or the government promised us the money and they're just late. Well, some of these things which implode or whatever, you look at the end of the day, they haven't paid that money. The people will have to pay Canada Revenue Agency, and that's really too bad. And they are the people there at the end are trying to save the organization. So what you have to do is to try and give them some defenses, and one of them is at their annual meeting, and as often as you can, get the executive director to tell them, and you put it in the minutes, that in fact everything has been paid. And if it hasn't been paid, then they should really make sure that gets paid. Or they should all kick in enough money to make things happen. One board I'm on recently had a big problem, and we were very conscious of all these things, and we decided to, we knew how much it would cost. We had to close the organization down, how much it would cost to pay, they've got about 30 employees, and what the reasonable remuneration would be for a notice provision, and we had that as a reserve, and we had to get past that reserve. So actually the executive committee, including me, it wasn't a lot of money, but it was, a fair bit. We all said, okay, we're going to send this out for another month, and we agree that we will personally make a donation to cover that if it doesn't go. Okay, and I don't recommend that, but that shows you how committed we were to this organization. So they should be aware of that. Now, a list of 13, I'm going to give you a list of 13 steps to help protect the directors of your organization. Get copies of, I've said this 3 times now, I guess it must be important. Get copies of the letters patent and the bylaws and review them. That's number 1. Number 2, ensure that the board meets regularly. It really is quite interesting. There's some boards that actually sort of hardly ever meet, or they just meet on the exception basis when there's something to do. You know, well, there's nothing to do till next year's something or other. They should meet regularly. Do you have written policies on privacy, harassment, vacation, that sort of thing? Is it inherently risky? That's number 4. Is it inherently risky? And if so, do you have insurance? Just regular, plain regular insurance. Do you deal with children or the elderly or people who are not, unquote, competent under law? If so, you should specifically have a risk policy to deal with those things. Do you have volunteers? Volunteers, what can they do? Can they speak for the organization? What risks are they? Next one is D&O insurance. I mean, I was at one Friday that it's pretty risky, and somebody mentioned the fee that was the cheapest I've heard. It was $2,000 a year premium, that's probably the lowest I've heard, because I go to a lot of these meetings and I get the executive director to come forward with the amount of the premium, and then we have this little discussion, as I mentioned earlier, about those factors, and then they go ahead and get it. But one of them is $60,000 because it's very inherently risky. Are the existing directors and officers reputable? I mean, a lot of people establish a charity to give themselves a job. I'm not saying doesn't sound good, but sometimes they have to, they establish it. If it's a person who's a founder, has got this terrific idea, they're putting their whole life into it, and it seems logical that they should be able to put bread on their table at the same time. And that's a very tricky thing to do. Review the financial statements. Is there a clean audit report? Do you know what a clean audit report is? It's not something that's a nice white paper. Look for the exceptions. There's always one for charities with respect to the fundraising that was cash. That's standard. If it's a charity, does it have an investment policy? Does it file its annual return? Jim will be talking about that. Is it funded by government, and how long is that commitment from government? I had one recently that had so a year-by-year commitment from government for a couple of $1 million, and the government told them 3 weeks ago that they were going to get money for the period beginning April 1, 2004. Right? And I suspect a lot of people have sort of seen those situations. Who maintains the corporate records? Are they up to date? And really, all charities should have a legal audit every few years. That means they have someone, I mean, I have a clerk that runs through those minutes just to see what they're up to. And have you looked at your income tax situation? I mean, do you meet the requirements for income tax? And I got a couple of tax things here, but I'm not going to get into those things because again, Jim is going to cover that. Now, some of the high-level things for a board is they should be responsible for the strategic direction. That's easy to write down, but you got to really think about that. And as you're dealing with a certain mission, does that mission still need? Should you tweak it a little bit, or you sit back? And usually charities have retreats and things like that, but the retreat should be the step back and look at that. Do you evaluate your risks of liability and losing your CEO? Do you motivate the CEO? And that's very tricky. I can tell you, as a lawyer dealing with charities, I almost always deal with a CEO. And you can see some boards that have a terrific relationship with the CEO, and other times the CEO spends most of her time trying to manage the board. Well, if you're the lawyer, you have to understand that. And I'm fortunate, although I've never been a CEO, I've been on a lot of boards, and I can sort of understand that relationship, but really do have to realize that. And when you get a call from a board member for a pro bono, I guess that could happen, pro bono, and you got to think of, am I talking to the CEO? Should I be talking to the CEO? Who is my client? Is it this individual? Is it the CEO? Is it the corporation? Because they're invariably incorporated. I usually like to think my client is the corporation, and I'm trying to do what's in the best interest of the corporation, and that one board member may not be. So do you want to take on that retainer to sort of create problems? If someone is really worried as a director, resign. I mean, it's not really, it's not really, it's not the end of the world, and people do resign, and you can send a nice letter of resignation saying you're busier in other things. Now, if you got somebody that hasn't showed up for the board for a long time, what do? Lots of organizations spend a lot of time trying to figure out ways to kick people off boards. If people don't come for 3 meetings in a row, we want it right in our bylaws that they're excommunicated from the organization. Now, you can do that. I always recommend you don't do that, because what you don't want to do with a charity is to have a bunch of people out there that were involved that now are feeling badly about it. So invariably, if someone hasn't showed up for 3 meetings in a row, they've either lost interest, you haven't got their email address right to know about the meeting, or they've had some other thing. And then you call them up and you talk to them and you say, should we, you're still interested, it's our annual look-see for the board. And invariably, if you give the person an out, they'll say, well, really, I'm too busy, and you can give them an out. So that's a practical thing. But I get a lot of calls, like we've had people that haven't made it. It's usually from some real zealot in the group that thinks everybody else has to be a zealot. It's not a good idea. Insurance, I talked about that, had a situation where there was some sexual abuse issues that are coming up all over the place. This was an organization that was in the business of helping out kids that have problems. And it was 20 years old, and they couldn't find an insurance policy. I mean, I don't know, anybody tried to find their insurance policy from 20 years? Unless you had the same broker, you probably wouldn't know. And they were never able to find. They'd had, like 7 controllers during that period. They just couldn't find it. Insurance companies aren't going to tell you, and they don't know who they changed their name and that sort of stuff. So keep good records of those things. So in summary, remember, figure out who your client is. That's very important. Is your client the corporation, the executive director, or CEO, or president, whatever she calls herself, or is it one individual board member? And you can get into all kinds of problems when you have that. There's nothing worse than a charity that's trying to properly be run, and it turns out that everybody on the board's got a volunteer pro bono lawyer acting for them. I mean, that would just be a real bad situation. I mean, all the lawyers in Valve would look bad. So try and help them with their problem. I have another copy of the most recent handout on director's duties, which I will leave up here at the front. Any questions? Yes. Yes. Well, the question is, if you have an organization that's got deals in an area where there's big risks, like if you're dealing with seniors that are going to fall, or you're dealing with people that aren't sui juris, that tends to be kids and stuff like that, then if that's because remember, charities do everything, right? I mean, they're all over the map. So if they have any of those types of charities, then in fact, you really should spend special time on your insurance coverage. And Terry talked about the different types there this morning and with respect to that. And you also should almost have an item on your board agenda looking at that every day. I mean, are our kids or our old people being properly treated? Because very large percentage of the lawsuits that come out relate to people that aren't sui juris, and it just gets very complicated. So, I mean, it's human nature, but that type of charity really should look at those things. The D&O insurance coverage is an issue. Okay. Any other questions? Okay, I'm going to stick around afterwards for a while. Now she's going to introduce Terry.
Thank you, Bill, for that very practical session. It's my pleasure now to introduce our final speaker, Mr. James Parks. Mr. Parks is a senior partner in the Toronto law firm of Castles, Brock and Blackwell, where he practices in the field of taxation and charity law. He's indeed an expert in the area of tax law. He's the chair of the Charity and Not-for-Profit section of the OBA, and he's a contributing editor of International Tax Planning. Excuse me. You're indeed fortunate that Mr. Parks is here to present to you today on tax law for charities. As Terry and Bill mentioned earlier, the law has been changing very rapidly in this area. And Jim's dedication is such that he wanted you to have the most recent, most up-to-date information on tax law, and he spent considerable time late last week updating the information. So I really appreciate his dedication, and VLS is fortunate to count him as one of our lawyers. Ladies and gentlemen, Mr. Parks.
One clarification I should make is I am no longer the chair of the Ontario Bar Association. Fortunately, I gave that up a year or so ago. I'm the past chair, but at the same time, I'm the vice chair of the national section of the Canadian Bar Association Charity and Not-for-Profit Law section. And as I'll mention later, that has taken me, along with some of my colleagues, directly to some dialogue with both the Department of Finance and CRA in connection with proposed amendments, which are very topical. Every time I come in this room, I think of the old days with the bar ed course, and when I was an instructor, one of the questions I always asked was what level of knowledge the people in front of me were coming from. So how many people in here would have been involved in seeking to register a charity? Okay. And I assume most of the people are involved in charities that are registered and are operating. Is there anybody here who doesn't have involvement with charities but is thinking of doing it? Okay. And my last question, and feel free to answer this one honestly, how many people here have a current copy of the Income Tax Act? That's what I thought. Okay. Well, this paper is pretty technical. It's not something I'm going to go through today in detail. It's there as a resource. One of the problems you're going to find is that unlike the things that Terry and Bill talked about, tax is not something that's intuitive. If you're a lawyer, you understand, generally speaking, what a corporation is or a trust, or what a director is or a member or shareholder. You get into the tax area, a lot of that intuition and things that seem logical don't necessarily apply. So one of the first questions as a pro bono lawyer is, what am I supposed to be doing here? Am I just flagging issues, or am I really supposed to know something and give some advice? And that's a pretty important threshold question. And I can't answer that for you, but I think it's important to know what's expected of you, because A, you're not accountants, B, you're probably not going to be involved in filing compliance forms, the annual report, or you may be if you're on the board and you're a volunteer, or you're the most knowledgeable of a group of people who don't know very much at all. That may for some reason fall to you. So this paper is written with that in mind. Just a little bit of background. Why do we talk about the Tax Act anyway when it comes to charities? Well, this was touched on earlier. Number one, registered charities enjoy tax exemption. So there's a thought they should be regulated more than other organizations. But other organizations are also tax exempt, not-for-profits, as Terry talked about. You've got registered Canadian Amateur Athletic Associations, with which I've had some involvement. They're pretty arcane, but they're important. They get out there and raise money for instance, Olympic athletes. Completely different from charities. And all of these rules I'm talking about here don't apply to them. And they don't apply to not-for-profits. So threshold question, do you really want to be registered? The answer usually is yes, not to be exempt, but to raise money. The key is the official receipt. That's how you get donor interest, by offering to share the cost of that donation with all of us through tax incentives. So that's why the Department of Finance and CRA are so I guess I would say, uptight about who gets through the gate here. To get registered, you have to satisfy CRA that you deserve it. The fact that you are registered or that your charity is registered helps, but it's not the complete answer. It's highly normal in my experience to come across charities that are doing nothing close now to what they were doing when they got registered. They may not even be eligible anymore, but nobody asks. CRA has limited audit personnel, so the mere fact nobody is saying anything shouldn't be taken as a clean bill of health. Bill mentioned the to-do list of things to look for, articles or bylaws, letters patent, whatever. If you get into the tax side, in theory, you would be looking at the application that was submitted for registration, the registration letter, and what it is Revenue Canada or CRA thinks you're doing. What are your charitable objects? A lot of charities discover what was a good idea 15 or 30 years ago to support Project A just doesn't work, so somebody thought, well, Project B sounds good. Completely different things that may be charitable, it may not be. The fact is people don't realize that it's an ongoing test. They often don't even go back and ask Revenue Canada whether it's okay. So that just as an overview of potential concerns for a pro bono advisor. A couple of observations on who does what. CRA is the administrator. They apply the law, they don't write it. So the Income Tax Act is there, it's complex, and CRA is the gatekeeper. The Department of Finance makes the law, and they come up with the policy, sometimes in conjunction with CRA, sometimes not. In Ontario, you've also got the PGT, who's not a tax person, but has an interplay with what the tax people do. For all of those reasons, we have an Income Tax Act that has become increasingly complex. Back in the 70s, the rules were very, very skimpy. We had reform in 1976 that introduced some concepts such as carrying on business and that sort of thing. That's all been brought forward. We've had case law now that's clarified that, but the problem still is 99% of this stuff is what Revenue Canada thinks. And you're up against it. They're judge, jury, and executioner at the moment. If they don't want to register you, current law says go to the Federal Court of Appeal. That's expensive, and there's not a great track record in that court. They're not really totally with it. They're interpreting law based on the statute of Elizabeth from 500 years ago about what's charitable. They're interpreting what is a gift, which is a common law concept. It's not written down anywhere in the Income Tax Act. So that's the kind of stuff you're up against. You layer that into all the technical issues about your disbursement quota, how much money has to be spent each year, what is a benefit, what taints a gift, and this stuff's all in my paper. It becomes problematic. I went to a focus group meeting a couple of years ago called by an outside group that CRA had retained to try to get a flavor for what the public knew out there before they instituted a lot of these current reforms. I was in a room with about 10 people. I was the only lawyer, and I probably shouldn't have been there because they thought I was a representative of one of my clients rather than an outside advisor. About 90% of these people were mom and pops who'd formed their charity on their own over the kitchen table, never read the Income Tax Act, didn't have a clue about any of this stuff. And yet CRA assumes everybody knows this stuff. And this is just implicit throughout. The last budget talks about the level of knowledge, and they want to improve it. While they're doing that, there's a very good website, as Terry mentioned earlier. It's there, it's free. If you can tap into it, the website's in my paper. There's a lot of stuff in there, probably way more than people at your level want to know, but your clients might want to know it. And so it's probably a good idea to direct them there, if for no other reason than just on the compliance side of red flags of things not to do to jeopardize your status. I haven't got time to go into all the nuts and bolts of this. The threshold questions Obviously, to be a charity, you have to have charitable purposes. And the four heads are advancement of religion, advancement of education, relief of poverty, and other good things that the law regards as charitable with a significant public benefit. That's what gets litigated. The tax cases are federal court of appeal cases where the judges have decided whether something is charitable. The law is not great in that area. As a practical matter, you don't go to court, you send your application in, Revenue Canada looks at it and says, we don't think it's charitable. You tell them it is, and they say, show me a case that says it is. You say, no, it works the other way. You show me one that says it isn't. Then you're at loggerheads. So for anybody who's going to be involved in the process, for a new charity, I recommend that you read that part of my paper about filling out the form, reading the guide for what they want, and taking all of that into account before you draft anything. Your letters patent are crucial because your objects will set out what you're going to do, and they have to be charitable. If they're partly charitable and partly not charitable, you're blown out of the water. Things that will make you not charitable: political activity, lobbying. You know, a lot of charities get into that gray area of we want to, solve this social ill or improve this cultural area, but to do that, we all want to go to stage B, which is convince people to do something. Well, if you're convincing politicians to change the law or people to vote in a certain way, you've got some trouble. There's a publication out there from CRA that's very helpful on that. So that's one no-no. The other area that's topical right now is foreign operations. As I mentioned, Canadian charities are not restricted to operating in Canada, but they are restricted to doing their own charitable activities. It's not appropriate for a Canadian charity to write a check to a foreign charity, with a very few exceptions. So when we see people in Haiti getting wiped out by a hurricane and everybody says, write me a check so we can send a bag of wheat down there, you have to be careful how you do that. If your client here is a Canadian charity that wants to help, it has to be careful that it goes through a proper agency arrangement or a joint venture agreement, or it has what's called a charitable goods policy that doesn't jeopardize its status. It's quite clear, especially under the new proposals in the budget, that a Canadian registered charity that writes a check to a non-Canadian entity as a gift will lose its registered status. And that's true internally as well. It doesn't have to be in Haiti. It could be in British Columbia. So it's not where the money goes, it's who is it that is getting it. And this frequently comes up with incubator organizations. You may be acting for a charity that says a group of people has come to us, they've got a good idea, they want to be a charity, they haven't got a critical mass, they're doing good things, can we write a check to them? The answer is no. They aren't a qualified donee. They will be if they get registered, and even if they're not for profit and not taxable, they are not a qualified donee. And you shouldn't be writing a check to them as a gift. I see this one come up quite often where people think, well, they're doing good things and it may even be charitable. Well, that's not the test under the Income Tax Act. It's fine under provincial charity law that as long as you're doing charitable things, there's not a breach of trust. So this is where a tax law sort of shifts over into the general corporate and commercial area. Tax is applied to what's happening. It isn't there totally in a vacuum. If registration is revoked, bad things can happen. The ability to issue receipts is lost. Also, the charity is subject to a penalty tax. They confiscate whatever's in there. Within a certain period, you've got a chance to transfer it to another charity. The budget is going to change that. Right now, it's an atomic bomb or nothing. If you breach the act, the only real sanction is revocation or nothing. The budget is going to introduce intermediate sanctions, so lesser offenses will result in some kind of a suspension of receipting privileges or a tax, but not necessarily loss of your whole ticket to issue receipts, and that's an important distinction. I've got a case right now where my client is a registered charity affiliated with another charity that was formed many years ago as a Friends of or a parallel foundation. Things have changed over a period of time. My client has morphed into something else. The main object for which the other foundation was formed has sort of changed. My client was on the list to receive a very significant grant from the foundation. And we discovered about a year ago that, unknown to the other foundation, although it's published right on Revenue Canada's website, they were revoked about 4 years ago. They are not only not able to issue receipts and no longer exempt, but they should have handed all their money over to Revenue Canada about 4 years ago. Fortunately, Revenue Canada has a relatively benign assessing position, which isn't written down anywhere. As long as the money goes to another registered charity or qualified donee, Revenue Canada, when it comes time to apply the penalty tax, will say the penalty tax is based on zero because there's nothing left. So if you come across situations where a charity's registration has been revoked, don't necessarily despair. There are administrative avenues out there to try to solve the problem. And again, that's unfortunately one of those things that you don't know unless you dig into it and ask. I mentioned related business earlier. One of the concerns in the charitable sector is lack of an even playing field. A lot of commercial businesses, quite rightly, complain that they are subject to tax, and yet charities and not-for-profits are out there competing sometimes for the same commercial dollar, but they don't have to pay tax on their profit. So why should they have that advantage? The 149(1)L exemption for a not-for-profit is a fact-driven test, but it basically requires you have to be organized and operated exclusively for purposes other than profit. It's easy to state the test, it's sometimes harder to apply it. And as Terry mentioned, if you truly are charitable at common law, the minister can refuse that exemption and require you to be registered. And there's an interesting case mentioned in my paper where that issue was debated, and the lawyers agreed that the organization was not a charity, and the judge stepped up and said, "Thank you very much, I will decide that." That's a question of law for me. And he also decided the threshold test of, and Terry, I think, might not have been aware of this case. A trust can be a not-for-profit organization, but only if it's a purpose trust. If it has beneficiaries, it doesn't meet the test that requires no income can be payable to a member, shareholder, or beneficiary. So in the Leuna case, the judge on his own came up with a solution and said it was a purpose trust, and therefore it wasn't void under the rule against perpetuities. So he was doing more lawyering than the lawyers in that case. But that is a question that you have to address when you're analyzing what the organization is going to do. If it's just not for profit, in Ontario at least, because of the broader definition of charity that Terry mentioned, it might still be regarded as subject to the PGT's jurisdiction. All right, so I'm going to jump over a lot of this stuff just because of lack of time. A little bit of technical stuff here on what kind of a charity you have. There are basically three things that a charity can be. It can be one, but not more than one of them. First, a charitable organization. That's the doer, the active charity, a school, a church. The second is a public foundation, which is a money raiser and usually a conduit that hands over more money than it spends. And the third is the private foundation, which, as the name suggests, tends to be a more closely held group, usually affiliated with a small founding group or a small group of initial contributors. Private foundations are the most highly regulated, and therefore, unless you have a family wanting to control the situation, it's usually better to try to have a public foundation. Although there are some tests that will prevent that if you have too many closely related people on the board or the source of funds is too narrow. The current amendments introduced December 2002 and now in draft legislation are going to change that to more of a control test rather than an actual source test. The person need not necessarily just be somebody who gave the money. The person has to be in a control position. But that's problematic for the reasons I mentioned, because control is worded so broadly that it includes influence. You can control a taxable corporation by owning shares. It's harder to see how you control a charity, other than perhaps by sitting on the board or being a major donor that influences policy. Issuing receipts. This is very topical right now because of the proposed amendments. In December 2002, the concept of split receipting was introduced. This was perceived by the Department of Finance to be a solution to a legal problem. You're probably all aware of fundraising dinners where you pay $100 for a ticket, you go and get your rubber chicken, and they give you a $45 receipt. Technically, in the common law provinces, that's not legal because a gift has to be a voluntary payment without consideration. If you pay $100 and get $50 worth of consideration, it's not a gift. In Quebec, it probably is because they have a civil law concept. Canada being a federal country and trying to do all things with its federal laws under the Interpretation Act is sort of stuck about what is the law where you have different provincial law. The Income Tax Act is going to be amended to deal with this, and it'll say if there otherwise would have been a gift, because there's some consideration, it will still be a gift at common law and therefore for tax purposes, as long as that advantage isn't too high. And there's an arbitrary 80% cutoff. So the fundraising dinner is saved, you pay $100, you get a $50 meal and a $50 receipt, that's fine. The harder ones are measuring what these advantages are. Your kid goes to school and you make a charitable donation, that's fine, but if you make the charitable donation because they come along and say the tennis team is going to Florida next year, all the kids on the team have to raise money, Dad, will you write a check to pay for the airfare for the tennis team? That may be so closely connected that that's either not a voluntary payment or there may be an advantage associated with it that would either destroy the gift or reduce the value of the gift. This is one of the hardest practical problems you're going to come up with, and it may be such an arcane area that you don't want to get into giving answers but raising red flags, that issuing receipts where there's any smell of quid pro quo is a serious issue. The other thing, just to plant some background information here, you may have been following the so-called art flip schemes that were proliferating up until the end of last year. These were promoted by commercial organizations who perceived a link between the tax rules and selling, in effect, what is very close to a security, I guess. The theory being they would package artworks or food or medical supplies, anything that could be bought for $10 and that could be valued at $50. So you get some expert to come in and say, you're really lucky, you're getting a bargain, this stuff's really worth $50, but the seller has a problem, it's obsolete, whatever, he wants to get rid of it. Doesn't mean it's not worth $50, but you're getting a bargain and you can buy it for $10. So you buy it for $10 and donate it and get a write-off based on $50. As you can imagine, the tax people didn't like that. They've attacked these over and over in court. Right now they're winning on the litigation side. But in addition, they've proposed to amend the rules, and this is where the problem hits the street. Under these rules, with a few exceptions such as certified cultural property or real estate or marketable securities, if somebody donates property to a charity, no matter what it's worth, their receipt has to be based on what they paid for it if they bought it within 3 years. And that's just an arbitrary across-the-board curtain that is going to hammer everybody. So even if you get 25 of the world's greatest valuators saying, trust me, you know, when I bought it for 10, it was worth 50, and everybody knows it's worth 50, it won't matter. The value of your receipt will be 10. What's even worse is there's a collateral rule that says if it's more than 3 years ago, if you had any intention of making a donation when you bought it, it's your cost way back then. So this gives you the ludicrous situation of somebody collecting masterpieces, being very knowledgeable, thinking, well, I've got a whole bunch of paintings. One day I might give that to the art gallery. Not right now, but someday. And because of that secondary intention, despite the fact that it's worth $1 million, if the person bought it for $100,000, these rules say your receipt's limited to $100,000. Now, we submitted vociferously in Ottawa to the powers that be that some of these rules are just too draconian, and the answer was, well, you smart aleck lawyers and accountants and promoters have brought this on yourself through all these phony art flips, and we'd rather have a law that's too broad and let people through the net based on our discretion than have to try to nail people by applying a law that isn't specifically precise. So that's sort of the framework that the tax rules are now, or in which they're evolving. We got about 5 minutes? Okay, I'll come now then to, and again, most of the stuff is in my paper. The most recent round of amendments, we had December 2002, the split receipting and a few other technical amendments. December 2003, the response to the art flips. Those were all technical amendments. They're out there now in draft legislation introduced in February, and I'm sure none of you would want to read them, but they're out there. In the March budget, as Terry mentioned earlier, we've had a major shift. A number of years ago, the federal government appointed the Voluntary Sector Initiative, which was a panel staffed by government and sector reps. And one of its objectives was to survey the whole area and come up with some recommendations on administration, law, donations, et cetera. They came out with a report that a lot of people thought would be deep-sixed. Surprisingly, and the CBA made some submissions on that as well. In the March budget, unknown to everybody, and I gather unknown in large part even to CRA, Finance has come up with a whole series of radical proposals. And this is major overhaul time. I touch on a few of those. They deal with, as I mentioned, intermediate sanctions, new penalties for carrying on an unrelated business, issuing receipts for too much, the form of a receipt, transfers of money between charities. Right now, the rules are very complicated with the disbursement quota, which measures how much money you have to spend compared to how much money you take in. And the so-called 80-20 rule, that you're supposed to spend at least 80% of the money you raise on real charitable activities, which is intended to prevent high overheads, too much fundraising costs, and that sort of thing. The problem is nobody's quite sure what's administrative and what's charitable. I had a case where we were acting for a major religious organization involved in sexual harassment claims. There was a global settlement, or a proposed global settlement, a large amount of money, and it was going to be funded through a new organization to hold the money in escrow. We went for a ruling and said, please tell us that spending the money out of this charity to meet claims under lawsuits for harassment allegedly done by employees is charitable. And the answer came back, no, that's administrative. It makes absolutely no sense. And anybody who knows anything about charity law would disagree with it, but that was the answer we were given. And they said, but it doesn't matter. There's a section in the Act where you can come and beg for mercy every year, and if you spend the money, just fill out a form and ask us to treat it differently, and we will. So for lawyers trying to give hard opinions on this stuff, it's extremely difficult because the law is often administered by fiat rather than by black letter law. In closing, a couple of other observations. Conflicts have been mentioned. There's another area of conflict here that you could easily get drawn into, and that is donor and donee. You're representing the charity. Somebody comes along and says, I'd like to make a gift. Can you help me out? Those are two different interests. If you start advising the donor, that may be fine, but if there are issues that aren't totally in sync there, you want to make sure that donor understands whether you are or are not advising that person, whether they need ILA, whether they don't get any advice at all. I've seen situations where that can be problematic, especially if you're drawing a will for somebody and you're acting for the client that's the recipient charity. And one last comment, we were talking about insurance. In my paper, I talk about structures, and we've already heard about parallel organizations, charities setting up NPOs so they don't carry on a related business or an unrelated business. I had a real flesh and blood situation where our operating charity ran a sports camp. The camp property was moved into a foundation for limited liability reasons, and sure enough, within about a year, a kid flew off a trampoline and is a quadriplegic, and the lawsuit is for $25 million. And it took the insurance company unbelievably, about 4 months even to admit coverage. The amount was so large that the charity legal advisors thought there was no issue about the insurance coverage, but they read every clause, they went back, read the application. Anything that an insurance company can find to get out of a claim that big, trust me, they will try. This became relevant on the tax side because these charities were moving money back and forth. And you can imagine if you're a director of the foundation that has the money that is supporting the camp, and that camp may be bankrupt, you're sitting there very nervous about continuing to put money into the hands of a potential trustee in bankruptcy. So a very awkward situation. Fortunately, the insurance company admitted coverage, and the claim is within the limits. So this thing is not going to bankrupt the charity, no matter what happens. And nobody thinks the claim is worth what's set out in the statement of claim anyway. And finally, one last little tidbit, again on insurance. One of the issues for charities is investing their funds. 10-year gifts are one way in which a donor can specify that money given is not necessarily on the list to be spent immediately under this 80-20 test. We had a situation involving some quite wealthy people who'd set up their own foundation. The financial advisors recommended a life insurance policy as a clever way to invest money and get a good return. There's a kind of life insurance policy called an exempt policy that is frequently sold as a universal life product where you don't pay tax on the buildup inside the policy. It's an alternative to an RRSP. Taxable people care about that. Non-taxable people would rather pay a lump sum premium and have the security of knowing that policy is paid for forever. Here, there was a breakdown. The sophisticated insurance brokers, in my opinion, blew it. They sold the wrong kind of policy. Premiums are payable every so often instead of having been paid up front. This charity now has a cash crunch. Plus, this policy doesn't fall into the right basket for the disbursement quota. So, there's an example of a whole bunch of people who should have made this work all dropping the ball. So unlikely to be an issue for small charities that are getting pro bono advice, but I guess the bottom line is if charities are successful and do raise some money and are investing it, you've got not only the legal side of having an investment policy, trustee quality investments, the Trustee Act, all of that stuff. You got the income tax side of what do you do with the money to stay on side under the Tax Act. And having said that, I'll just mention I've got some other Excise Tax Act, Retail Sales Tax Act, and other stuff that you can read at your leisure. Time for questions?
Time for questions.
Probably none after that.
I have a client who's offered to reimburse me or pay me by way of issuing me a tax receipt. Is that something that you would consider?
Your client is prepared to,
Recognize my time as a donation?
yeah, in fact, there's a policy paper on that. If you bill them and then you make a donation so they can pay your bill, there's nothing wrong with that. But they can't issue a receipt for your services. You can only issue a receipt for property, and that's the problem. People who give their time cannot be given a receipt. But professionals who donate their time and then send a bill for it and donate it by paying for their own time with a check, that's okay. It sounds kind of artificial, but that converts the gift into the property of the money you've paid to pay your own bill. And that's clearly okay. All right.
Sorry, can I just take you back to your comments about the changes on the donation of art?
Yep.
Are you saying that there's the best art purchased in the last 3 years? Is that, I didn't.
No, my concern is that if somebody bought a Rembrandt 12 years ago, thinking they might donate it during their lifetime to a charity, the way that law is written now, when they donate it now,
What happens if they inherited a Rembrandt and they donate it to charity?
well, now the question is the application of the deemed fair market value rule going back to cost, and the fact that the 3-year rule is extended back to the date of acquisition, whenever it was, if there was any kind of an intention to donate the property. That's one of the issues of how do you track back to what the cost is. If you inherit something, your cost is the fair market value at the time you got it.
So I'm sorry, so the cost of the fair market value at the time you got it, and then you had to pay the donation, does that come into play in some way? So I guess I'm worried.
That would be a little harder to establish if you inherited it.
It would be unless it was stated in a will.
Well, this doesn't apply to gifts on death, but if you inherit it from your parent, it's harder for you to be alleged to have acquired it with the intent of giving it when you had no intention at all. You just received it. If you went out and bought it, and there was a secondary intention to say, I really like this thing, but one day I may just give it away. It's this fuzzy secondary intention that is causing the problem. When I put that to the people in Ottawa, they said, as usual, it's only there to catch the scammers. Just trust us. And I say, yeah, that's easy for lawyers to write trust us opinions for clients when we're talking about multi-million-dollar transactions, and they just don't get it, unfortunately. All right. I should just mention, by the way, that I've got all my particulars on the front of my paper, and I don't mind at all if people want to call me or send me emails if they've got, flesh and blood issues that they want to just kick around. I'm obviously not going to charge for that. Thank you very much.
Thank you. Thank you very much, Jim, for that very clear presentation on a very complex issue. I'd like to just take this opportunity to thank all our speakers. You've managed to take a somewhat dry subject and make it interesting, and you've really had a gift for taking the theory and putting it into practice, leaving us all with a very good appreciation for the day-to-day real legal issues that face the voluntary sector. Your insights and information will no doubt prove very helpful to this new group of VLS lawyers as they take on pro bono work. I'd also like to take this opportunity to thank the Law Society of Upper Canada for co-sponsoring this event. I'd particularly like to thank Andrea Bosniak and the Continuing Legal Education Department for all their work. And finally, I would really like to thank all of you for coming to this session and for joining Volunteer Lawyers Service. Lisa and I look forward to working with you in the time ahead. And very, very finally, please complete your evaluations because we do look at them and we'd like to improve it every time we offer this CLE for all our new lawyers. Thank you very much.